Hello and welcome to the 2025 Franchise Times Legal Legals Virtual Summit. In this year's summit, we have a panel featuring 5 legal experts who break down the underlying conflict between equity and efficiency in the franchising model, as well as key issues franchisors and franchisees need for success, all through a legal lens. Today's panel is led by Jeffrey M. Goldstein of Goldstein Law Firm. Based in Chicago, Jeffrey practices in courts across the nation with a focus on distribution and franchise litigation. The panel also includes Nicole Ligori-Miklich of the firm Urso, Liori, and Miklich, where she represents franchisees and development agents in litigation with franchisors, as well as David Kaufman, founder and senior partner at Kaufman, Gildlin, and Robbins, who represents franchisors and large franchisees owned by private equity firms. Additionally, we have Craig Trachtenberg, a partner at the firm Fox Rothschild, who litigates domestic and international disputes, as well as corporate revitalizations, as well as law professor Adi Ayal of Bar Ilan University. And now, with everybody introduced, we throw it over to Jeff, who will take the panel from here.
Thank you very much for the introductions, Matt. I agree, this is an incredible panel. What we're going to be doing today, my name is Jeff Goldstein. You can see each of our names under our photos. It's going to be a very informal panel and also a very fast panel. We're going to run through very many issues, and some will be theory, some will be individual areas of law. So both operators, academicians, and anybody else watching will get a little bit out of it. We're on target for a little bit over an hour. Let me give you a very quick introduction of how we're going to be proceeding. We're going to do a little bit of theory at the beginning of our panel. I'll start out by giving my views unsolicited and not those official views of my law firm, but of my personal views. After that, each of us will be doing a small presentation on kickbacks, unilateral changes, pricing restrictions, and goodwill. And that just so as you're looking forward, David's going to be doing pricing restrictions, Nicole's going to be doing unilateral changes, Craig is going to be doing goodwill ownership, and if there's enough time, which I doubt, I will hit with some supply restrictions and kickbacks and things of that nature. Adi, Professor Ayal, is going to be our resident law and economics rover, and if he zeroes in on anything that raises his intellect, he's going to be participating and providing great intuition on that issue. And I should say, anybody on our panel, we've done this in the past, if anybody has ideas that they want to express, this isn't a formal procedure where we go one to the other to the other. So it may end up in a little bit of a free-for-all in the sense that it's not going to be going in exact order. I would like to start off by giving you my personal views of where we are in 2025 with regard to franchising. The conflict has been omnipresent since franchising began. It's pervasive and it hasn't subsided. Almost all franchisee arguments revolve around conflict. And the way of arguing, embraced by both sides, franchisors and franchisees, is on the grounds of fairness. And that's what franchisees almost always argue. If you look through the Franchise Law Journal or even do a search on Lexis or Westlaw, you'll see that the proponents of franchising are always arguing that there has to be fairness, and that's what's wrong with franchising. No matter what the issue, you could take all the issues we have today, goodwill, pricing, and some franchisee advocates will argue pricing. In my opinion, that's really taken us nowhere and taken franchisees nowhere. It's a black box. Usually black boxes are interesting intellectually. This black box, when you open the top, everybody falls through the bottom. and there's a chasm, and franchisors are able to latch on here and there with a little bit of neoclassical economics from time to time. And the one I love the best, well, if franchisees don't like what they got, they don't have to buy it. Or if they don't like where they are, they can leave. Now, that's a classic Adam Smithian concept. We come to the market, we have a supply and we have a demand, and nobody's forcing you. It's not a communist society. And that's how franchisors have survived intellectually for 35 to 40 years. It's incredible. And the question is why? There just hasn't been any intellectual, I would say very much intellectual development from the initial day 35 or 40 years ago, where Bob Pervin put down the AAFD fairness franchising prongs. They haven't changed very much over the years. They're somewhat absurd. No franchisor is going to adopt them, and I don't think any franchisor has. And so the AAFD, like other franchise organizations, have still embraced and still espouse only fair franchising. And as I said, it's a black box to nowhere. It's shifting sands. Nobody's ever going to win who embraces that argument. So you might say, well, what are we supposed to do? Just throw out the whole thing, and whatever franchisors want to do, everybody should be cool with it. No. My solution is that we embrace efficiency, not fairness, but efficiency. Now you might say, whoa, that's what franchisors want. But no, yes, they want it to some extent. But I think if we were to increase efficiency using a proper model of efficiency, it would have overflow effects where we would also increase fairness. Now, efficiency in my model would not be only a neoclassical model. And by that, I mean, it's not just something that's embraced by franchisors in the IFA. Well, the franchisee doesn't like it, he can leave. Franchisor can do whatever he wants. That's not what I'm talking about. That neoclassical model is another black box, but this time we need to get into it. We need to unlock it and look. And inside that neoclassical box, underneath the supply curves and the demand curves, you're going to find transaction cost economics. And that pretty much embraces, when you begin to take a look at that, it's not that hard. You can skip over the math and everything else. Franchisees have enough money. They pay thousands and hundreds of thousands of dollars to law firms every month. Let them get an academician. Let them take a look at some of the transaction cost issues. And by those, I mean adverse selection, moral types of hazard, opportunism, and lock-ins after franchisees pay a certain amount, sign a rental agreement, and they can't get out, and then post-term covenants. I'm not talking about post-term covenants with, let's look at the reasonableness of the number of years in the abstract, like a smile on a Cheshire cat. That's not what I'm talking about. So I think we have to look within that black box. I think, luckily, transaction cost economics gets us there. So you might say, well, what are we going to do now? That's nice that we have all this theory. How would you stop franchisees from arguing about fairness? No, I think what we need to do is, you can still argue it, but I think we need to take a look at the transaction cost economics, the moral selection, some of the concepts are great. They're hostages, ugly princess hostages, and there's all kinds of very, very intuitive concepts. And I think Adi worked with Oliver Williamson and at the beginning, and this is a great, it's not something in conflict with neoclassical economics the way I look at it. It's something that forwards it. It looks below, what's below that supply curve, what's below the demand curve, the black box. So I think the evolution of common law has stultified when it comes to franchisees. Unconscionability, covenants of fair faith and fair dealing. I know Craig might disagree on that. The idea of the covenant of good faith and fair dealing is dead on arrival in most places. I mean, it was supposed to, in my opinion, be some type of freestanding maybe cause of action, but it didn't have to be. That didn't necessarily have to be tethered to a very specific provision on discretion. That's where almost every court has gone now. Does it do something? Yeah, it does 2 out of 10. If had anything else that you hired to do 2 out of 10, you'd fire it. I mean, covenant of good faith and fair dealing, you're going to put it in. Yes, it's not going to get you anywhere except in very few places. The state franchise law, federal franchise law in this climate. And I do have to call out Keith Miller. He's one of the most amazing people to me in terms of going out and on his own time also, going on the Hill, meeting with congressmen for years and years and years. He's amazingly effective. And he's one of the very few people that I would say has done a job that really franchisees should be proud of. So where does that leave us? It leaves us with more writing, more research, more academics to look at the transaction cost economics with franchising. And I have a very specific disclosure issue, and I think everybody here might have disagreed with me last time. Maybe not, maybe it was a different issue. But on disclosure, you've got to, in my opinion, however we carve up an industry, whether it's hamburgers, whether it's fast food, the franchisee needs to be, if it's 10 different franchise offerings, there's got to be 12 salient or non-salient or material, whatever word we're going to use, for each franchise system that the franchisee, the potential franchisee, can look at and compare. Now, I know last time most people started saying they can go to California, they could go here, they could go there. That's not how it works, in my opinion. There's a big, rich research on behavioral economics and cognitive economics. The franchisee has enough trouble divorcing himself from the concept after you tell him he's going to lose $250,000. He's not traveling to California. He doesn't even read his own franchise agreement, his own FDD or the franchise agreement. So I think there's got to be what's called a nudge in behavioral economics, and Adi may disagree with me. The nudge here can be putting this small document together. Now, I know Dave's going to say, well, I'm working with a group, and it's a cool group. It's interesting, you'll talk about. But it doesn't get to what I'm saying. I say take the 10 hamburger places, 12 issues. And by the way, one of those issues is going to be unit profitability. Okay. The arguments that franchisors have gotten away with for so long, well, it's costly. Nobody's saying it's not costly. The question is, on net, there's going to be costs of doing it and the costs saved by franchisees not being destroyed. And I think it'll also help franchisors. But I've talked long enough. I didn't even get to my Nash equilibrium. So who he was waiting. All right, who would like to?
Let me jump in with you, Jeff, because you mentioned so many topics, open so many windows that I think we're going to have a long time trying to kind of go deeply into them. Let me start with the black box concept that you spoke about that actually came up in some ways. When we say black box, we mean basically here is a term that we all understand, but when you come to apply it, there's so many details there that the term doesn't really help us. And that's what you said about fairness. I don't think there's anyone who argues that things should be unfair or that fairness is not important to human beings and to businesses. But fairness is such a broad and vague term that you can use it pretty much in any way you want to. And I think that's the issue. I think efficiency, and forgive me, being an economist, I should be jumping and agreeing, let's take efficiency instead of fairness. But I think efficiency suffers from the same drawback. So it's a broad term. There are so many ways of calculating it that in practice, you bring two economists, both will argue for efficiency, and they'll reach opposite conclusions in any realistic case. Similar to you argue about if something is fair or unfair. Well, it depends on a lot of factors. So let me open that up just a little bit. I would argue that fairness is mostly about giving case-specific discretion to the judge. It's basically saying, I want to be able to say my situation is unfair. I don't have these 12 parameters that you were discussing. But if I manage to talk about the details of my case, the judge or the other side, someone will understand what I'm talking about, and we could argue about specifics. But in extreme cases, people know what is fair and what is unfair. We all, I think, know the old adage about obscenity. Who knows how to define it, but you know it when you see it. Fairness, in a way, is like that. When you know it's fair or you know it's unfair, that's helpful.
That can't happen with franchising. I mean, take a look at, I mean, I don't see how I think if you looked at it on a continuum of definability, ability to define, you'd have one end maybe efficiency and one end fairness, unless you're telling me something can't be on the continuum. But clearly efficiency, whether it's Pareto optimality, whether it's something, you can have 6 different cost benefit analyses, but they're all going to be guided by the same parameters. I don't know. David, what do you think?
This is almost beyond my pay grade, because the notion of fairness to me is anathema. What is fair is what the parties agree to in their agreements. And you said earlier, I'm not sure you believed it, Jeff, but you said earlier, you don't want to sign it, don't sign it. Listen, fairness is the most subjective, one of the most subjective emotions there is. You know, I don't think it's fair I lost my hair 30 years ago. Does that mean I'm entitled to anything? No. You know, it's fairness is in the eye of the beholder. Okay, contracts are in the eyes of judges, not necessarily arbitration, where notions of fairness unfortunately creep in all too often. We are not prone here, and I think I've made this clear. We are not prone here to do an abstract economic analysis of franchise relationship. What we are very much devoted to is ensuring that because we represent almost exclusively franchisors, except very large franchisees owned by private equity. We're very proud of the fact that we've never introduced a new franchisor that has failed. And that is because we make new franchisors satisfy themselves and us that, in fact, the economics will work. That the projected revenues, the expenses varied by market, varied by region, et cetera, low, medium, high, that it all ties out so that a franchisee after year 1 is projected in a realistic fashion. This is not item 19. This is the franchisor proving to itself and to us, proving that after year 1, the franchisee will see a return on investment between at least 15 and 20% of the initial investment.
So you agree that's fair? That's part of your program. You agree it's fair to see what a franchisee would earn in a
after year 1, and then we have to see the ROI for the franchisor. Look, the number one reason franchise networks fail, one side or the other, is making too much or too little. You have to make sure before introducing a new franchisor that in fact both sides are going to be making an adequate return on investment. There's no guarantee. But you know, as much as they say the past doesn't guarantee the future, the past can be an awfully good guide if you see returns and you see gross margins, and then you see cost of occupancy, cost of labor, cost of goods, legals, this, that, the other. Bring it down to the bottom line. Deduct royalties, deduct ad fees. What is the franchisee left?
So why don't you, David? Why don't you write an article? You write a lot of great articles in the Franchise Law Journal. So next month, you're going to write an article that item 19 should be disclosed because we believe it's fair, and we won't even take a franchisor who doesn't take that fairness into consideration.
You mean mandatory item 19?
Yeah.
No, not a fair. No new franchisor is going to. I'm not going to mandate an item 19 for a new franchisor.
Why? It's helpful to the market and provides good information, and they already have the information. So with your guys, we don't even have a problem of the cost of developing it. Why are you going to take it home with you and have dinner with it alone? Why not bring it out to the franchisees?
If there's a quantum of information that's reliable, you know, a number of company-owned units doing business for a period of time, more than a year, of course, yeah, sure, that goes in, because without a 19, you're going to have a very difficult time selling franchises. But to make it mandatory, I think, would be grave error and prejudicial to new franchisors. You know, it's funny, a lot of folks forget that franchising started and continues to this day with concepts nobody thought had any legs. And then they exploded. My favorite story is a fellow named Larry Harmon, and I'm not that old, but I know the story, and I met him. Larry Harmon comes home from a visit to the East, and I think he lived in Utah, Colorado or Utah, I forget. And he tells Mrs. Harmon, oh, you know, I just did a deal. We're getting Kentucky Fried Chicken franchises. And this is in the mid-50s. Nobody had heard of Kentucky Fried Chicken. And his wife looked at him and said, Larry, what are you talking about? Kentucky Fried Chicken? First of all, we're in Utah. I think it was Utah. Number one. And number two, nobody's heard of this. Why would we do this? You know, you look at that and you say, maybe he's crazy. Well, today Harmon Enterprises owns north of 300 KFC units. Of course, KFC proved to be a very dynamic brand, at least in the beginning for the first number of decades. And so having that, by way of example, make that mandatory item 19, the way KFC started was Colonel Sanders driving around in a pretty beat-up old jalopy, how's that for an old word? And he would go from restaurant to restaurant with his pressure cooker and his spices, and he would fry up some birds. And if the restaurant liked it, he would say, okay, I'll sell you the spices. My royalty is a nickel a bird. And that's where the whole thing started. So an item 19 there would have been dramatic.
I think initially, when you didn't think I was going to ask you about mandatory, I think you gave a very good reason why it is important. Craig, what do you think? I'm going around the horn. We're going to hit Nicole on this.
Well, I think that item 19 is a very good thing to have if you're selling franchises. I don't think it's a good idea to have it as a mandatory disclosure, and I've seen a lot of abuses of item 19. I'll give you an example of an abuse of item 19. Private equity goes into a industry, and they have a roll-up of existing widget manufacturers, let's say. And so they convert the widget manufacturers to company-owned widget manufacturers, and then they want to franchise the manufacturing of widgets. They have an item 19 that reflects the roll-up and the profitability and expenses of the companies that they just bought. So for a franchisee candidate, they look at this and say, hey, this can make money. In reality, these businesses may have been operating for 30 years, and they may have had a whole slew of customer contracts, the types of things that are not apparent or go deep into footnotes in item 19. And the franchisor, through franchise brokers, also known as consultants, will sell the viability of this concept based on the roll-up of existing operations. But the franchisor is inept. The franchisor doesn't know how to get a new franchisee manufacturing. And the franchise system fails, even though the company-owned units operating for 30 years survive and thrive. So that's only one example where an item 19 doesn't really tell the story. I think that candidates probably shouldn't buy franchises that don't have item 19s, but this is also an issue of entrepreneurship. Maybe they think they could partner with the franchisor and do well. There's been a lot of franchisors that have started without item 19.
Let me ask you a question. Let me jump in for 1 second. If we put David and you in a room, okay, and we told you you have 5 hours to come up with a rule, item 19 is going to be mandatory. Say Trump wakes up in the morning, makes that call. He just fired some more attorney generals out in California. He makes the call and says item 19 is mandatory. All right? We both know that you and Craig would have the rule, and you'd have the exceptions to try and grab as many of those kinds of false inferences that can be drawn by a franchisee. According to you guys, we shouldn't have cars because there could be a car accident. The question is overall whether the item 19, I think, and we obviously have different views, but Nicole, what do you think on this? We weren't even going to do an item 19 on here, but apparently we are.
We're there now. We're in the conversation now. So let me say a couple of things because I've been listening carefully. And one of the things, Jeffrey, that you talked about and Adi is efficiency. And I would suggest that in the concept of franchising, we should think about that efficiency, or at least the concept of efficiency, can include proficiency. And that's what David was talking about. David was talking about that his firm takes great pride, appropriately, in the fact that they don't roll out franchisors who are not proficient in whatever it is that makes money. And when we talk about item 19, my view is that no single item in any FDD is enough on its own to disclose a franchisor's proficiency. And so when it comes to item 19, there are lots of franchisee lawyers who have publicly stated and written, and it's been published, that nobody should buy a franchise from any franchisor who doesn't have an item 19 in the FDD. Now, I understand the basis for that opinion. It's a fine opinion for those folks to hold, but is it realistic? Probably not. There are some very wildly successful franchisors who don't include an item 19. There are new, proficient, but nascent to franchising franchisors who don't have an item 19. And there are lots of item 19 disclosures that I think we've all seen that are problematic. I mean, Craig gave a great example. We've all seen many. I don't necessarily think that the state of franchising or prospective franchisees' abilities to understand what they're getting into will be improved by a mandatory item 19. The franchisors who want to include an item 19 fall into some pretty broad categories. There's those who have good numbers, good data, and they want to disclose it, and they do. And it can be used for whatever it can be used for. There are others who use the item 19 in a manner in which it shouldn't be used. And that takes time to unpack and to understand. It should not be mandatory. It doesn't help prospective franchisees enough to mandate that franchisors have an item 19. It's not useful enough. It's inefficient. It's inefficient. What is helpful are the franchisor's financial statements. That's helpful. That's useful. And if they're audited financial statements, it's a lot more useful to a prospective franchisee than an unaudited, adulterated item 19.
And Jeff, let me jump in for just a second. You're talking about efficiency. How about the efficiency of the market? Maybe franchisees shouldn't buy franchises without a item 19. Why don't we let the market decide that?
Because there's too many inefficiencies. You're asking me. There's too many inefficiencies right now. They're informational failures. In my mind, you're talking about the purchase of a franchise. The number of informational failures, qualitatively and quantitatively, is prolific right now. We were going to be focusing on the issues that are ex post after they sign, but the market for purchasing franchises now, the FDD is a joke. It's like throwing out some meat to wild wolves and everybody runs over the FDD to fight about what's in it, what's not in it. There's information that can be disclosed, and franchisees are, as I said earlier, they don't have any great advocates in terms of academics, and they're eaten alive. Take a look at the Franchise Law Journal, for instance. That doesn't mean they don't strongly advocate for fairness. That's not getting anybody anywhere. In my opinion, we're in the same position as we were 35, 40 years ago. That means that somebody hasn't advocated properly or drawn a right path to get where we need to be. That's the conclusion I draw. I'm not taking anybody out individually by name. I mean, right now there are very few law firms, almost all the law firms that started out franchisee, then went franchisor, franchisee. Nobody really cares as long as the dollars come in. That's basically how it works with.
I think there are some very well-known franchisee side law firms that would really take issue with that appropriately, where the lawyers have worked very hard over the years and are very intellectual and frankly publish very good work in the Franchise Law Journal and do not represent franchisors.
I'm not talking about whether they do a good job in court or for the franchisee. I'm talking about looking at a static point in time, 35 years ago and now. Nothing has been developed. Franchisee associations have been ineffective. Common law is stultified. There's no development. There's no where it should be. And the articles, I'm not talking about whether it's well written or a nice point. I'm talking about broad sweeping changes similar to what happened in labor, in the labor area. And that's the problem. When somebody speaks out and makes an observation like I do, they're hammered. And I think that's pretty unfair.
There are franchise associations in this country that have had great success, that have negotiated very well for their constituents, that have made great strides in terms of the content of franchise agreements, in terms of purchasing co-ops, in all sorts of very important areas. Not to mention, while I grant you there's not been sweeping federal legislation, there have been great strides in the states, in some states in which there are franchise protection laws, obviously most notably California.
All right, I hear you. I would just fall back on the argument that the few firms that do franchisee work are basically involved in, I would say, short run types of good work. I'm not saying whether the work is quality, but it is short run, in my opinion. It hasn't led franchisees to a better.
We see quite the opposite. The larger chains, and I mean the biggest of them, the franchisee association. The bigger the chain, the more influence the franchisee association has. These franchisors understand that, first of all, these franchisees have skin in the game, and they're the troops. They're on the ground. They're doing business every day, and their input and advice and counsel, whether it's on products or services or advertising and marketing, has proven invaluable, and it makes a very good team. And I've seen them represented by some of the finest franchise lawyers in the country. We know who they are. The folks who represent franchisees who are really solid, quite intellectually hefty. We all know who they are. We all know where they come from. Minneapolis, New Jersey, Peter out in San Diego. These folks have done a marvelous job, and for good reason. Good franchisors listen to their franchisee associations. Not for nothing, but two of McDonald's leading profit drivers for lunch and for dinner, for breakfast rather than for lunch, came from franchisees that were conceived decades ago. The Big Mac was invented by a franchisee, and the Egg McMuffin was invented by a franchisee, and it's a good thing McDonald's listened and rolled it out. And then, by the way, if you do a little reading, you'll find out when McDonald's back in the 70s said, okay, we're going to roll out breakfast, most of the franchisees were up in arms. There was a civil war. What do you mean open for breakfast? Right? We do lunch and dinner. I'm not coming in at 5 in the morning. I'm not doing this and new equipment and new shifts and eggs. I don't know from eggs. It's just ironic that one of the things that really drove profits for McDonald's franchisees were vehemently opposed to by them until they had to acquiesce. They had no choice. But the numbers that McDonald's went into that with, showing return on the investment and the increased profit margins to be enjoyed by adding breakfast, were astonishing and proved to be entirely accurate.
Why has unconscionability gone backwards? Why has the covenant of good faith and fair dealing gone backwards? Is it because all of that great intellectual work that's gone into it? So I understand what you guys are saying. I'm not taking a shot at any individual. I'm talking about broad sweeping.
But Jeff, don't you think that's a little bit apples and oranges? Because what we're saying there has been progress.
I don't agree with it.
I'm sorry?
I don't agree with it. If you have a good hit and you have a franchise association on a co-op, in the next 2 years when nobody's looking again and that franchise association is disbanded or not as active, it goes right back to the ratcheted effect of the franchise. You've got a standardized contract that rarely is above others. If everybody's done such a good job, why do we have no franchisors that have signed on to any of the minimum standards that the AAFD, for instance, has out?
Because all of those standards call for fairness, and fairness is a subjective term. And it's something, listen, you're saying good faith and fair dealing went backwards. No, good faith and fair dealing went back to where it was originally. It was stretched like crazy in the 80s to an absurd point. It made no difference what the contract said. Is this fair? Is this just? Is this equitable? That's not what the implied covenant was supposed to be. The implied covenant was only supposed to be used if the contract didn't address the subject, or if it was vague on that subject. Then you could invoke the implied covenant to supplement what the contract said. But in the 80s, you started getting all these crazy decisions. I remember a guy named Steve Scheck, franchisee up in Massachusetts, suing Burger King. His contract says you have no exclusivity. And he said, well, yeah, but that breaches the implied covenant. And they found in his favor. Now, eventually, that same court in Florida that found in his favor reversed it in a case called Burger King versus Weaver when it said properly, if the contract says something clearly, that's what's fair.
Dave, the covenant of good faith and fair dealing, I mean, I think I disagree with you in terms of origin or the genesis. I think it started out where there were gaps in the franchise agreement. There were gaps. I think it may have gone full circle. I don't think it was ever started out as in a way that is restricted as you are saying. I mean, I think it was also there to prevent any type of unfairness by, say, the franchisor in this case, that would undo and take away the benefits of the franchisee. Whether that's abstract or not, I think that's really where it began. And then you move further along and it got restricted, not surprisingly, sort of follows what I was saying about the development of the common law. It's gone from more free sweeping, and franchisors have eaten franchisees' lunch for about 35 years. We disagree on that, but I guess that's where we are. Adi, is there anything here that you wanted to comment on?
Yes, actually. I think the discussion shows exactly how difficult it is to use the general terms. So fairness being so sweeping and subjective, we can each attack it from our own direction. And efficiency is a similar broad statement. And I think what you're all saying in a way is we need more precision when we want to apply these concepts. So instead of speaking about efficiency and let the market decide, or does it have enough information in it for it to be efficient? Let's dive into the details. So you mentioned transaction cost economics and supply restrictions. And these are exactly, they go together. So the whole point is, as the judge looking at a case, okay, let's avoid the personal position from which we come to this, but the judge looking at a case basically wants both franchisor and franchisee to have a successful contract based on what they expected, and he's trying to look into how clear the agreement between them was. Now, I think what David said to begin with, and Craig jumped in with this as well, is that if they know what they're signing, then their signing is their definition of what is fair. And I would go further, if they understood what they're signing, then what they signed should be efficient from both their perspectives. The problem is that after the fact, when something was unclear, and it only becomes clear after the fact because some change was introduced, and they have some restriction on outside supply, for example, and the franchisee might look at that and say, all I want to do is buy some of the goods needed somewhere else and not pay exaggerated prices that the franchisor is charging me for napkins or paper cups, when what I'm actually paying him for is know-how and recipes. But then the franchisor comes in and says, I don't want to charge you extra on cups, but I do want to make sure that you use the appropriate ones, that you don't skimp and buy from some cheap provider elsewhere. and my brand name is suddenly diluted because you're using bad products. Or I want to know how many you're actually selling because my royalties are based on your sales, not just in money, but in amounts of, let's say, dinners or drinks, but I can't monitor you. And when I force you to buy my paper cups, that helps me monitor how many drinks you served. Now, these are things that are more precise. They apply in some cases, they don't apply in others. And I would argue that if you want to know what's efficient, you need to know which cases these apply to more than others.
Adi, you're going to love this. Talking about real world. I can't name the networks. We represented one of them. You'll know who they are. There was one pizza network, this is going back about 25 years ago now, 30 years ago, that compelled franchisees to participate in system-wide purchasing of certain products, including cheese. Now, there were some legal issues on that we had to deal with, and it wound up that there was really no ban on that. Okay, but there was one very well-known pizza chain that had that feature in it, where all franchisees had to purchase cheese from the same source designated by the franchisor. You can guess what the source is. And the other chain didn't have that. So it was up to the franchisees if they were going to buy cheese from that source or buy cheese from another source as long as it met specs. Well, when you have the first chain going to the cheese producer saying, I have 5,000 restaurants locked into your cheese, what's my price? Versus the other chain going to the cheese producer saying, I'm not sure how many franchisees are going to buy from you. What's my price? It wound up that the price the first chain paid was 1/3 the price that the franchisees paid in the second chain. Not 1/3 off, 1/3. That has since been rectified. All chains now use this compulsory purchase protocol for that reason.
Louis, should that all be disclosed to the franchisees, all those kinds of kickbacks or rebates? And I know you wouldn't call.
They are disclosed. The fact that they had, the FDD made it abundantly clear, we made sure, that you must purchase in accordance from suppliers we designate for certain products. And then in I think it's item 8 or item 11, we disclose what the rebates are. How much we receive versus our total revenues, et cetera. It's all disclosed.
And I think that the franchisor can do whatever it wants with those funds. It's not required to put those funds in the ad fund or share it with franchisees in any way.
Wait, oh, you mean rebate funds?
Right.
Yeah.
Let me just jump in quick. Nicole, what do you think about the many franchisees multiple times a week? When they're talking about rebates in this general area of supplies that we sort of migrated to, their view is that franchisors are in the business of franchising, and they should make their money from the fees, the initial fees or the royalties, but not from manufacturing or from warehousing and things like that. Putting aside the disclosure issue, I think there's a big expectation problem of franchisees. And talking about fairness, they think it's unfair more than almost anything is for the franchisor to be making money on any product or service that is not a traditional, narrowly identified royalty or something of that nature.
I agree that that is very frequently the franchisee's expectation, and that is often their perception as a franchisee of what they're getting into and how it ought to work financially for them and for the franchisor. And here, in my view, is where a streamlined FDD could be very helpful in terms of managing prospective franchisees' expectations, which in turn really ought to help the franchisor as well. Very often, I'm sure you get the phone calls, Jeff, I get them all the time. I just found out that my franchisor gets this rebate and they can't do that, and they told me it was going in the ad fund or what have you. And as you all know, most of the time, I then look at the franchise agreement in the FDD, and it is clear, as David just described. It's in item 8. We own these companies are suppliers, some of them are mandatory. We may get rebates, we can do whatever we want with the rebates, and it says it. But these franchisees are not calling me or you, Jeff, or anybody else because they knew that all along and they're just now upset about it. They're calling because they truly didn't read, didn't understand, didn't pay somebody to review this FDD and explain to them what would reasonably, realistically occur when they entered into this relationship. And now they're stuck. They have, in some cases, multiple units, in some cases, development agreements, what have you. They're locked in, and now they've learned this, and they're angry. They're really angry most of the time, very, very angry. And a streamlined FDD, an electronic, whether it's a slide deck or a video or something, where, I mean, David said less than 5 sentences, I think, to make this clear. That would be very beneficial to get that information really upfront in the hands of a prospective franchisee. And then they do have choices, to Craig's point. They do have choices because not every franchise system has a franchisor that also has interest in the supply chain or takes significant rebates or takes significant rebates that it's not required to put a certain percentage in an advertising fund or whatever. There are some out there. And so to Craig's earlier point about these folks have choices, that's information that matters. And if it's in front of these folks, now granted, we all know some of these folks are going to fall in love with the concept and they're going to buy in no matter what. That's life. We know this. But there are some who are more discerning and simply don't find the information or don't understand it. And then they do become this caller that you and I get on the phone every week, Jeff.
Let me jump in with that, because that's exactly where transaction cost economics come in. Because what Nicole is saying is that it was in front of them and they could have or should have known. And here's the question: what should they have known? So the fact is, if they didn't read it and they don't know that some call it joint ownership or rebates are going on, if they don't know any of that because they didn't read the contract, then we have one type of problem. But if we're all lawyers, right, we see contracts, the contract says I may receive some rebates, or there are, some of these companies are jointly owned, but that doesn't necessarily give the average franchisee enough details to see if this is going to be an exploitative price or a reasonable price. Now, I'm not saying they have to have all of the numbers in front of them ahead of the time, but they do have to have enough so they're able to make some sort of reasonable business inference. Is this going to be a source of excessive profit for the franchisor that I had not anticipated? Because that's a type of lock-in. If I have the frame of the contract saying there will be rebates, and I thought it would be something small, let's not go into numbers right now. Turns out it's something huge relative to the royalties I pay. This is a different contract than I anticipated. And now comes the question, what are you going to do ex ante so the franchisee knows what the franchisor is going to get in the area of, so he can make a rational business decision and not feel locked in ex post because he thought he's going to pay 5% extra on these things and it turns out to be 50%.
That's David, the exact issue. Exact issue of good faith and fair dealing. Let me just twist the facts a little bit. The disclosure to the franchisee when they bought in is that we may in the future require mandatory purchases. Or the disclosure is we have mandatory purchases and we'll charge you 5% more than the manufacturing costs, and we'll be the distributor. Those are two different issues. But let me give you a third issue. The franchisee is in the system for 5 years. And then the franchise system goes to mandatory purchases. And the franchisor, when it goes into mandatory purchases, has market power to buy the purchases much cheaper through efficiency, but doesn't pass those efficiencies on to the franchisees. They keep that secret profit to themselves. That's where good faith and fair dealing comes into the locked-in franchisees, because the expectations were one thing and nobody could predict this set of events. So
David would recoil at your definition of covenant of good faith and fair dealing there, Craig.
Assume that good faith and fair dealing means meeting the reasonable expectations of the parties to the contract. If the contract and the disclosures explain what the expectations are, and then the circumstances change, there's room for a court to go in and say the guardrails aren't here. This is when you signed up with one expectation. As a system developed, it's another expectation. So, in our system, in the common law system, we're stare decisis. We have to follow previous cases. These are the guardrails. If you go to a civil law system, good faith and fair dealing applies to every transaction, and you get different outcomes in a civil law system. But that's in the United States, except for one state, we don't have a civil law system. And we're stuck with the courts thinking in the past and applying new facts to the future. So I agree I'm in David's camp on good faith and fair dealing. It evolves, but it's only for the things that people couldn't expect.
Well, they couldn't expect things that you can either have a gap, Craig, if you're going to use the expectation as the criterion.
But you're touching on, I have news for you. You both and Nicole and Adi are touching on something that is, to me, of primal importance. The current disclosure format for franchising is antiquated. I mean,
we all agree.
Come on.
We all agree.
That's right. We all agree.
I go back a long way. I wrote New York's franchise law, for God's sake, and that was a long time ago. Today's disclosure format, I mean, first of all, last time anybody looked, and it was Franchise Times, by the way, but I think 25 years ago, only half of franchisees read the FDD. And you look at it, who in this day and age of video, who's sitting down to read a 250 or 300 page disclosure document, as opposed to a streamlined video presentation with click-throughs for more information if you want it. Here on average, our units gross this. You want more information, click here. The other thing is, and this is something, I served as an advisor to what's called the NASA North American Securities Administrators Association Franchise Project Group. That's all that's the FTC, ex officio, plus all the state franchise regulators. They're responsible for coordinating regulatory activity, and we're sworn to secrecy, so I can't say much. What I can say, what I do know, is that the notion of having a new state cover page, and I gave them a sample, in one page gives critical information. When did this company start? How many company-owned units? How many franchise units? When did it start franchising? What's the initial fee? What's the royalty? What's the ad fee? What's item 19 summarized, et cetera, et cetera? Who are the officers? Who are the directors? Do we have any bad litigation? All in one page, so that if you're buying, let's say, a pizza franchise, you can download, for 12 different chains, 12 one-page summaries, compare and contrast. But we're not there yet. On the other hand, we're not there yet. On the other hand, I notice certain states, particularly the state of Washington now, is driving franchisors crazy. They are sua sponte issuing new requirements for franchise agreements and franchise disclosure documents that weave in the notion of fairness. I'll give you one small example. Covenants not to compete. State of Washington is not taking a position. It can say what is fair or not fair in a covenant not to compete. Now, covenants not to compete are subject to judicial review, no question. But when did the bureaucracy take over determining, and what skills or backgrounds do they have to make a determination if a covenant is fair or not fair? We're seeing a lot of that. The FTC started moving in that direction on the regulatory front. By the way, the FTC is now frozen. because President Trump cut an executive order, no new regulations, and the FTC was about to revise its franchise rule. But if you remember, it cut an advanced peek into that about a year and a half ago, and it's focusing on covenants not to compete, almost declaring them per se unlawful, which is absolutely crazy. At the same time, there's no progress on yet to report, but it's being worked on a modified disclosure platform, one that reflects the 21st century, not the 20th. And there's the other thing you should be aware of. Somebody said franchise brokers, also known as consultants. I must disagree. There are some really fine franchise consultants out there. They're terrific. They work with companies hands-on to help them calibrate initial fees, royalties, ROIs, franchisee ROIs, etc., all the kinds of stuff I was talking about earlier. And then there are franchise brokers who, not all of them, but a number of them have created a dark cloud over franchising because they just get paid to sell and they'll sell whatever. They are about to, first of all, they already are in one state. They're about to have their own disclosure regime and their own disclosure document saying essentially, here's who we work for, and it ain't you, and here's who pays us, and here's who we've represented in the past, and so forth. That's coming down the pike. But the primary issue to me is the lack of a 21st century year 2025 disclosure protocol that works for franchisees.
So item 19 wouldn't be in your page.
I'm sorry? Yeah, it would.
He did say, David included item 19 in his one page.
It's mandatory?
No.
Okay. Okay, to me, it's
If there is one.
All right, Jeff, let me ask you a question.
yeah.
Or it'll have to say there is no item 19. Your one page could say there is no
Right.
financial
Or
performance representation.
average net, et cetera. Hey, Jeff, let me ask you a question. What
Yeah.
franchise do you know that shows a profit at the end of the year, other than the mega franchisees? All right. But what, more customary franchisee that leaves money in the establishment to be taxed and shows a profit, therefore?
You're obvious, McDonald's.
I'm sorry?
McDonald's.
No, never mind McDonald's. I'm talking about more customary, smaller franchisees. No franchisee leaves any money in the bank at the end of the year to be taxed. No, they'll expense it out. And by the way, no harm there. That I don't know if your law firm does it, but we're sort of diligent around here. Vigilant is what I was going to say, to make sure that we're not going to get double taxed. And if there's money at the end of the year, take it out and don't leave it double taxed.
Yeah, but you're using a defense that there's some kind of tax issues that would militate towards not showing. Look, if franchises are in the business, from a neoclassical point of view, they've got to be making a market rate of return, however it's manifested on the books or off the books. All right. And if that's the fair rate of return that franchisees, somebody buying into the business, deserves to see. And I've heard a lot of excuses here today, and I don't say that in a personal way. I've heard a lot of excuses why that can't be. It's a shocking concept to somebody taking 101 economics with supply and demand, where the actual price and costs in a market that's allegedly free with 300 pages of disclosure, you can't find out ahead of time whether you're making a fair rate of return.
But you cannot ever, this is what I'm trying to get at. Franchisees generally, wisely, by the way, don't leave money as profit sitting in cash on December 31, because that subjects it to tax. They take it out, so they'll show net profit zero. Your law firm.
What about individual non-franchise businesses? According to you, individuals who are selling are to do the same thing. So the buyer would be sort of a dummy to ask the seller, what the profits are in the business. So according to you, all businesses should transact where nobody knows whether the businesses are making a profit or not. So you have to use proxies, how long the business has been around and things like. Look, let me jump in for a sec. What I want to do is try and do a lightning round, because everybody did prepare something. We ended up talking about nothing. Well, great things, but not really the issues you get assigned. So I know you guys did a little work. Is it cool if everybody did like a minute or two presentation on their issues? Just do like a lightning round. Is that doable? Nicole, you want to hit it?
My topic was unilateral changes, and we have talked about the keys behind the issues that arise from franchisors making unilateral changes. This is a classic occurrence once the franchisee thinks they have a good understanding of the system and of their business, and we say they're stuck, and frankly they are, but they could be very happily moving along, and then the franchisor makes some kind of unilateral system change, and they pick up the phone. They call you, Jeff, they call me, they call whomever. And we're faced with all of the things that we've talked about today, questions about efficiency and good faith and fair dealing, and the type of change that this is. As we all know, you have to look to the franchise agreement. You have to look to the applicable law. Franchise agreements very typically provide for incredibly generous leeway when it comes to the day-to-day operations and day-to-day changes in the operational side of the system, and frequently state right in the agreement that the franchisor can make these changes through its operating manual, its ops manual. We've seen cases, and they're not new, right? I mean, Jeff, you talked about what's gone on in the last 25 or 35 years. 25 years ago, we had competing cases. 2010, we had a hotel chain where the franchisor tried to make changes to its customer loyalty program, tried to impose an additional 5% on gross room sales. It is the Super Hotels. Yeah, it was. 2010. That case is 2010. We all still know it. The court found that because the franchise agreement provided for 2% fees, the franchisor breached the agreement by requiring the total 7% fees for participation in the customer loyalty program. At the same time, roughly, we had a different hotel chain, the La Quinta case, where the franchisor instituted changes to its reservation system. And the franchisees said, oh, whoa, that's a breach. And the court said, no, it's not. Look at your franchise agreement. There's this section right here. It's called changes. Now, interestingly, we all know these cases. The La Quinta case, where the franchisor said, we can make this change, and the court said, you're right. That cost franchisees a total of $35,000 over a 10-year period. The Bird case was a change from 2% fees on gross room sales to 7% fees on gross room sales. I suppose we could have a very lengthy debate, which we won't have right now, about fairness and whether maybe courts don't write about it. Maybe it's a factor, maybe it's not. I'll leave my 2 minutes there.
A quick question. Why isn't that a perfect place? And I know this would go beyond David's view of the appropriate use of a covenant of good faith and fair dealing. But isn't that a perfect place to use a covenant of good faith and fair dealing? Although there's not a word discretion, say there's just, well, the system standards manual can be changed by the franchisor. Don't you think that's a perfect place to use a covenant of good faith and fair dealing?
I think that if the franchisor was, I'll say unfairly, we're talking about fairness, doing something to benefit itself and to harm the franchisee's ability to do what it was required to do under the contract, then it's a good place to make the argument. But because these franchise agreements were clear on these points, that's, as you know, Jeff, where the argument is going to hit the iceberg.
That's right. And, we didn't bring this up at all, but there's a whole vein of great theory on the standardized contract and whether points are salient or not, which feeds back into the behavioral economics. And, that's a big question as well. I mean, the fact that the franchisee doesn't demand to see any profits himself, he's going to have no clue what that means, even if it's disclosed regarding a system standards concept. And I think that's what Adi was talking about earlier, where there's a lock-in under the transaction cost, so that in a sense, that the smart franchisee will know that there's going to be some type of change, but he doesn't know how much. And that's where the lock-in occurs. And that was the derivation of the tying, which is sort of dead in franchising as well. But I'm rushing, and I hate to do that. Craig, are you going to talk to us about goodwill or?
So goodwill is the ability to have brand recognition and repeat customer loyalty under the trademark law. The trademark holder has to protect goodwill under franchise agreement constructs. The goodwill of a franchise business belongs to the franchisor under the contract law of the United States. It could not be otherwise. But in reality, there is some goodwill that may attach to a franchise unit, which really doesn't belong to the franchisor. For example, an extraordinary lease or an arrangement by which a celebrity visits a particular franchised unit. That celebrity may be under contract to the franchisee, not to the franchisor. So to protect goodwill, franchisees should have a contract with however they protect their own goodwill, such that it's not included in the franchise agreement and won't be lost or conveyed to the franchisor without compensation for that. I will say that there are some state statutes that recognize goodwill in certain circumstances, maybe not in traditional retail franchising, but heavy equipment and other types of franchises. And I will say that in the European Union, it is not unusual for distribution agreements to give the distributor a goodwill indemnity from the franchisor in the event of expiration, even contractual expiration. EU distributors can obtain, depending on their country and the local laws, a payment of a percentage of their royalties, historical royalties, upon normal expiration of the contract. So this area is evolving slowly, but it's a good idea to recognize that goodwill belongs to the franchisor under the franchise agreement, and for franchisees to document when there is goodwill outside of the franchise agreement, and it's protected in favor of the franchisee.
Quick question. When you're saying I thought you were headed one direction. You said the goodwill belongs to the franchisor, and then you linked it to the trademark, which I agree. And then you came back and said there's goodwill that the franchisee in certain cases has. Are you saying the franchisee has that goodwill only in those extraordinary types of cases you said? Or is it possible for the franchisee just working for 5 years or 7 years to have built up a goodwill regarding that business, if you could abstract it and analytically cleave it from the trademark? Are you against it?
I believe that there are some state statutes that can be interpreted to give the franchisee compensation for goodwill at upon termination. It's not readily available, but I think that if you parse some of the state statutes, I think California in some instances allows that. Also, in specialty areas like beverage alcohol or heavy equipment manufacturers, there is some states have recognition of goodwill upon termination. And the other thing I was saying is in overseas, even upon expiration, notwithstanding the contractual language, the local laws may give a goodwill compensation to the distributor whose agreement expires by its own terms.
David, what's your stick today? Pricing?
Oh, pricing's an old issue. It used to be that a franchisor couldn't mandate pricing maximum or minimum, but about 25, 30 years ago, the U.S. Supreme Court in a pair of decisions said, yeah, they can as long as it's disclosed. Only one state, California, still has its ban. Technically, in effect, it hasn't been enforced in 30 years, so nobody worries about that. But I did want to deal with two notions. One is the franchisor's ability to move and shift the system and compel its franchisees to follow. I know I've heard, we've heard some incidents here that sound negative. Now I'm going to give you a couple of positives, and they just occurred. About 5 years ago during COVID, when nobody could leave the house, no restaurant could be, nobody was going in a restaurant to eat. Nobody was doing much of anything. You had your groceries delivered, and people were like, index on the delivery beds, and it was crazy. But in one of the swiftest moves we've seen, one client, Taco Bell, another the former client, Pizza Hut, immediately turned around and responded and had its franchisees respond. In Taco Bell's case, they had the $5 deal, and then they had the $10 bring Taco Bell home with you. It had shells and meat and stuffing sauces and the beans and the drink and so forth. In other words, you could have your Taco Bell restaurant in your house. So successful, and Pizza Hut did an analogous thing with the triple play. So successful were those quickly introduced campaigns that actually Pizza Hut and Taco Bell that year, 2020, saw increases in same-store sales at a time when nobody could come and sit down in a restaurant. So franchisors' ability to move, shift, and compel franchisors to follow is not a negative in most instances. That's what you're paying your franchisor for, to be clever, swift, respond to the marketplace. Remember, franchisees, they're not just competing against other franchisees, they're competing against non-franchise brands. So if you have a Pizza Hut on one corner and a Johnny's Pizza across the street, that's the competition. Okay, and people in franchising too often forget about that. The whole point of a franchisor compelling system changes is to keep its system ahead of the competition, or at least even with it, but preferably ahead of the competition. And in those two instances, they did. And by the way, franchisees celebrated that.
Those are good, David. I agree. Those are good examples. Those are good examples of the franchisor acting quickly, instituting changes that is a rise in the tide for the franchisees and the franchisor. But there are instances where we've seen these unilateral changes that really do not benefit the majority or any of the franchisees at all, or nearly to the degree that they benefit the franchisor. And so sadly, we do have those examples as well.
And here is exactly where I want the economics to go a little bit deeper into it. Because as a lawyer, if you show me a contract that says that the franchisor may introduce changes in the future, that is expansive. That allows for all of these, and it does not allow for separating the wheat from the chaff or the good from the bad examples. And what I would want, and economics has to offer, not just in transaction cost economics, but other fields as well, more parameters for being able to separate the cases where this is a change instituted solely or mainly to benefit the franchisor, and those cases in which this is a change which reacts to a change in the market, a change in the business plan, or a change in some external factor that the franchisor can point to and say, don't block me from doing my job here.
Yeah.
You know, Jeff, I can't disagree with Adi. Adi has written more books than we've read.
Yeah, I like the way you phrased that last part. But David, I think it would begin to expand the covenant of good faith and fair dealing a little bit. But would anybody like to add anything to the comments? And
Always put together such a lively, interesting panel.
Well, I wanted to thank you, Jeff. This has been a real pleasure.
Yeah.
It was very informative. I like your offer that anybody who has questions can shoot them to us, and we'll take
Absolutely.
All right, guys, I appreciate it. Great conversation, great insights, intellectual, analytical, everything that's fun. David, Craig, Nicole, Adi, thank you guys very much, and have a nice day.
Thank you, Jeff.
All of you very much.
And everyone.
Thanks,
Pleasure.
everyone.
Take care. Bye.
Bye-bye.
Thank you again to our panelists, and thank you to our viewers for tuning in to this year's Legal Eagles Virtual Summit. As a reminder, this virtual summit will remain on franchisetimes.com for more viewings, and also for more Legal Eagles coverage that is also available on franchisetimes.com. Thank you again.